Good afternoon, everyone. Myself, Dr. Leena, Assistant Professor, School of Law, Maharaja Agrasen University, Baddi District, H.P. Today, the topic of discussion is the essential elements of the valid contract. From the morning to the evening, what we enter into the contract. From the early morning to the night, we enter into the number of the transactions during the regular course of our life. And those transactions and the activities directly or indirectly, expressly or impliedly results in the contract. Like when we go to food, buy the food or order the food in the restaurant, we can say go to the medical shop to buy the medicine, or for the entertainment, we always enter into the contract. To satisfy our needs, to satisfy our requirements, we contract with other persons, parties, and such contract, it forms the basis to enter into the agreement. Maybe that agreement is oral or the written, that may be expressed or implied, which ultimately result into the contract. And the law which deals with the contract is called the Indian Contract Act 1872. So when we go to the contract, we find that the contract is the term which is derived from the Latin term contractum, which means drawn together. As I told you earlier, that when we from the early morning to the evening to the night, whenever either we goes to buy the food or order the something in the restaurant to eat, we enter into the contract. So contract is the term which is drawn. It is the agreement which is drawn together. It is an agreement that is entered into between the two or more persons, subject to the certain terms and conditions for the lawful consideration. It is an agreement which is entered into two or more persons, and that persons are known as the promisor or the offerer, promissory or the acceptor, subject to the certain terms and condition and for the lawful consideration, and it is constituted when there is a acceptance by the one party of an offer that is made to him by the other party to do or not to do something. So when we goes to the definition, what the term contracts, as when we goes to the definition of Pollock, we find that Pollock defines it every agreement and the promise which is enforceable at the law is a contract. So agreement should be necessary and the promise, that agreement should be enforceable by the law. And when we goes to the definition of that is given by the Hillsbury, it says a contract is an agreement that is between two or more persons, which the part is intended to be enforceable at law and is contracted by the acceptance by the one party of an offer made to him by the other party to do or abstains from doing something. In the same way, Selvin defined it as a contract is an agreement, creating and defining the obligation between the parties. Okay? So it is an agreement which describes as per the definition given by the Selvin, it is an agreement between the two parties which prescribe what the parties will do, what are their obligations between each other within them. But when we goes to the definition as is given under the section 2H of the Indian Contract Act. Section 2H of the Indian Contract Act defines the contract as an agreement which is enforceable by the law. Our Indian Contract Act simply says there should be an agreement which should be enforceable by the law. So the formation says, for the formation of the contract, as per the Indian Contract Act, there must be the agreement. Agreement consists of the offer and the acceptance. And that second condition says, as per the definition, second condition says that the agreement should be enforceable by the law. So what we find as per the definition, it says that the contract consists of the agreement and the enforceability. So an agreement, now what is the agreement? Let us first discuss what is the agreement. Section 2C of the Indian Contract Act 1872 defines the agreement. It says every promise, every set of the promise forming the consideration for each other is an agreement. Section 2C of the Indian Contract Act 1872 says every promise, every set of the promise forming the consideration for each other is an agreement. Thus, what we find as per the definition, to create an agreement, there must be at least two parties. Yeah? There must be the proposal or the offer from the one party and to contract, and that offer should be accepted by the other parties. That means there must be the acceptance to that offer from the other party to the contract. And that means what is necessary? There should be the offer and the acceptance. One party should give offer and other party should accept it. So what we find that, let us go to the previous slide, what we find that agreement to be enforceable, section 10 says an agreement. There should be an agreement. There should be the offer and acceptance. There should be an agreement. What is the offer? Offer, it says it is an agreement. As per the section, as per the Indian Contract Act, offer is when one person signifies to the another. When person signifies his willingness to the another to do or abstain from doing anything with the view, with the purpose to obtaining the assent of that other. To such act or abstention, he said to make a proposal. He said to make a offer. Okay? So what is the offer? When sometimes person says that he wants to, he gives his willingness to do. He to do or to abstain from doing anything with the view to obtaining the assent of that person. That person is making the offer. And when that person to whom the offer is given accepted, then it is acceptance, and then it is there is a promise, and that promise is converted into the agreement. Agreement is created, promise is created, it is converted into the then contract. So, and when the agreement is created, when the agreement is formed, there is the formation of the agreement. As per the Indian Contract Act, it says it should be enforceable by the law for the contract. So what, and that means an agreement to be enforceable must possess. That means, as we had discussed, that there are two things, an agreement and that should be enforceable by the law. And when the agreement is consisted, is created, that agreement should be enforceable by the law. And when it is enforceable by the law, it says for the agreement to be enforceable by the law, it must possess the essential conditions of the valid contract as is defined under the section 10 of the Indian Contract. So only 10 agreements which are enforceable by the law as per the, when it fulfills the section essentials which are mentioned under the section 10 of the Indian Contract Act, only that is it can be enforced. So what it means, all the contracts, they are agreements, but all agreements is a contract which are not enforceable by the law is not contract. Right? Agreement to of social and the domestic natures, they are not a contract. Like invitation for the birthday party, when we get the invitation for the dinner, it is just a social and social contract. They are not the we can say they are not the contracts which are enforceable by the law. So when we go to the further, as let us come to the section 10 of the Indian Contract Act. Section 10, what? Because it consists of the validity, it says which contracts are valid, which are enforceable by the law. So for section 10, it defines the essentials. It consists of the essentials for the valid contract, which are enforceable by the law. Section 10 of the Indian Contract Act 1872 says all the agreements are contract if they are made by the free consent of the parties competent to contract for the lawful consideration with the lawful object and are not expressly declared to be void. So when we go through the section wordings of the section 10 of the Indian Contract Act, it says all the agreements are contract if they are made by, that means it prescribes a certain condition. If that conditions are fulfilled, only then the agreements are the valid contracts. Only then the agreements are contract. And that is the free consent to the parties. Parties must be competent to contract for the lawful. There should be the lawful consideration with the lawful object, and that contract are not expressly declared to be void. So let us discuss the essentials of the valid contract. So first, there should be the offer and acceptance, as we have discussed of what is the offer. One party should give the offer, another party should accept it. There is the two parties, offer and offering, promiser and the promisee. The person who gives the offer is known as the offerer, and that means one person who signifies is that person who signifies to the another person, who gives the offers to the another person, about who says to the another person what about his willingness to do or abstain from doing anything with the view to obtain the assent. From doing anything with the view to obtain the assent of that other person to whom he gives the offer. Such an act and abstention is said to be make a purpose, is to make an offer. And when that person to whom the offerer gives it, whom the offer shows his willingness, signifies his willingness, that person, if he accepts it, that means there is the acceptance, then there is the agreement. So it says when we goes to the, we find that if for the valid contract, first condition, what is there? There should be the two parties, because one party can't be the offerer and an offering. So there should be the proposal and the offer, and there should be the acceptance. Acceptance is made when the person to whom the proposal is made signifies his assent thereto. The proposal is said to be accepted, and the proposal and the offer, when accepted, becomes a promise. And when what we find in the definition of agreement, agreement says every promise or every set of promises forming the consideration for each other is an agreement. So when the proposal is accepted, it becomes the promise and it is converted into the agreement. So there should be the offer and acceptance. Next is that there should be the free consent. What is the free consent? We find that there should be, for the valid contract, there should be the consent between the parties. Consent as per the section 13, it says two or more parties are set to section 13 of Indian contract. It says as per the two or more parties are set to consent when they agree upon the same thing in the same sense and at the same time. That means there should be the consent side, Adam. Parties should agree upon the same thing in the same terms at the same times, only then there is the consent to the contract. But consent, as per the essentials of the valid contract, as per the essentials as conditions which is defined under the section 10, it says that the consent is said to be the free when it is said to be free. Now let us move to the section 14 of the Indian Contract Act. Section 14 says consent is said to be free when it is not caused by coercion, which is undue influence, fraud, misrepresentation, and mistake. If there is neither the coercion, no compulsion, no undue influence, no fraud, no misrepresentation, no mistake, then the consent is set to free. If there is the consent is taken under the coercion, fraud, undue influence, misrepresentation, and mistake, then it says it is not a free consent and the contract is not a valid contract. Another condition is the party should be capable to enter into the contract, capacity to enter into the contract. The parties to the contract must be competent to enter into the contract. And when we goes to the section 11 of the Indian Contract, it says any person is competent to enter into the contract, provided he must be the major. He is the major. He is of a sound mind and he is not disqualified by the law in the force to the contract. So the person who is a minor, who is of unsound mind and who is disqualified by the law in the force by the law in force to contract, that party is incompetent to contract. Parties must be competent, must be capable to enter into the contract, must have the capacity to enter into the contract, and that is should be according to section 11. And what is the major? Who is the major? Who is the minor? Now the question arises. Section 3 of the Indian Majority Act 1875 says a minor is a person who has not completed the age of 18 years. That means the person who is above the age of 18 years can enter into the contract. Below the 18, he can't be enter into the contract. The age of the minority, it is extended to the 21 years if the guardian of the minor person or the property is appointed by the Guardian and the Wardship Act. Guardian and the Wards Act 1890. And the person should be of the sound mind. That means he is capable to understand the terms. He is of the contract. He is capable to take the decisions, and the person should not be disqualified by the law to enter into the contract. Only that person is the competent party who can enter into the contract. Now the next condition is the lawful object. What is the lawful object? It says that the contract should be lawful. When we go through the section 23 of the Indian Contract Act, we find it says an agreement that is entered into with the unlawful consideration or the object is declared void. Consideration or the lawful object, that means what is the lawful object? Lawful object, that means the contract should not be object of an agreement should be lawful. It should not be unlawful. It should not be such which is forbidden by the law. It should not involve any injury to the person. Like you can't enter into the contract for the murder. Object is unlawful, which is forbidden by the law. You can't enter into the contract on the basis of for the fraudulent purpose. You can't enter into the contract with the object to do the fraud to another person, because it is prohibited to give the injury to the person or the property of the another, which the court thinks it is opposed to public policy. It is immoral. You can't enter into the contract because the object, the purpose of entering into the contract is unlawful. It should be valid. It should be lawful. Another condition is that there should be the lawful consideration. What is the first of us? Let us understand what is the consideration. Consideration is the one of the most essential elements to the formation of the contract. It refers to the both parties. Consideration. What is the consideration? Consideration is something should be done in the return. Something in the return. Like if you go to the market to buy something, to go buy we can say food, what the person, shopkeeper, what the seller gives to you, a food which you prescribed, he is giving the offer and you accepted it. So what he had given the food to you, and what you have to give the prize money to you. So a contract, it is a price for the contract. It is something to be done for the contract. Like let us discuss another example. Like a person who sells a house to the B for the rupees of the 50 lakhs. Here, what is the lawful consideration? Object is the lawful because the person wants to sell the house, which is not for the fraud purpose. So what is the law? Should be the consideration should be lawful. What is the lawful consideration? Lawful consideration is the rupees 50 lakhs for the seller, for the person who sells his house. And the lawful consideration for the buyer is the house. So both the parties should do something in the return, and that should be the lawful consideration should be there. So a contract without the consideration is void. It should be lawful. It says, in the other words, we say a contract with the consideration is not valid. Like in parties who is not competent to contract, it is invalid, and it says it is not valid and it's not enforceable. Another condition is that legally enforceable. Intention to create. It says another condition is intention to create the legal relationship. It says when the party enters into the contract, there should be the intention to create a legal relationship. How says it says because a contract is to be enforceable by the law, it must create a legal relationship between the parties to the contract. Mere domestic and the social nature do not give, it doesn't create any legal relationship, any legal consequences. Let us discuss the example like a lawfully wedded wife is entitled, she's entitled to enforce her claim of the maintenance by filing a suit against the husband under the section 125 of the CRS. However, she can't sue her husband for the pocket money or the other things which is outside the legal necessity, like the jewelry, like the car, etc. Because this is of the social. If the husband even promises, that is, it says it is just of the we can say social nature, domestic nature, which can't be enforceable by the law. So for the legal enforceability, let us sum up what is necessary. Legal for the essential, what is the essentials of the valid contract? There must be the two parties, offerer and acceptor, offerer and offering, and there should be the consent side and a free consent to the parties. Parties should be competent to enter into the contract. There should be the lawful contract consideration and the lawful object. And the parties must have the intention to create the legal relationship. There should be the legal relationship exist between the when they enter into the contract, and there must be the possibility of the performance. That means it should not be declared void. It must be certain. There must be possibility of the performance of the contract. Law, we says it should not be declared void by the law. So one of the another essential elements is the possibility. It is the performance. If the performance is impossible, not expressly declared void. If it is declared void, you can't perform it. A contract, we can say in the even the impossibility of the performance, it says a contract to construct a building within the 2 days, it is impossible. If there is the within the 2 days you can't construct the whole building, and the law should not declare it void. If the law declared it void, like if the war is exists between the two parties, our comment says, our legislature says, you can't enter into the contract with that nation. That means our legislature has declared to enter into the contract that country void. So, and with this, I completed my lecture, and all this is about essentials of the valid contract. Thank you.